Guillermo, and then we'll follow up with our legislative counsel, Katie.
That's okay. He wants to answer.
So Chris, welcome.
Well, thank you very much for taking a moment this morning to allow me to talk to you a little bit about H244, natural organic reduction. Understanding that one doesn't need to be eternal to be memorable, I thought that I would offer a brief statement to you and then answer any questions if that's okay.
Sure.
The Vermont Funeral Directors Association supports passage of House Bill 244, allowing for natural organic reduction, moving forward, referred to as NOR, as a form of final disposition of human remains. This legislation provides Vermonters an additional choice for disposition as an alternative to green burials and cremation. H244 proposes that the Office of Professional Regulation will create rules, regulations, provide licensing and oversight of this new industry. The VFDA has provided the House Committee an OPR detailed testimony regarding NOR and how it can meet the consumer's needs in a safe and professional way. It is safe to say that most Vermonters will not initially choose NOR as their method of final disposition. The same was true for green burials when first approved. However, we've seen increased interest and growth in this disposition choice. It's also safe to say that following the passage of this legislation, if a facility opens in Vermont, it will serve a multi-state demographic that sees this form of disposition meeting their philosophical needs. The VFDA very much encourages your committee and the Senate as a whole to pass H244, and I appreciate your time this morning and be glad to answer any questions.
Thank you very much. There's no changes that you see in this bill or concerns that you have. It sounds like the association is in favor of the direction of the bill. Is there any specific wording changes you want to see?
No, not at all. I mean, we've given extensive testimony through the House Committee. Katie's been a great asset to this whole process, and we're very comfortable with this bill as worded moving forward.
Okay. Is there a likelihood or any kind of restriction in here that in terms of cremation and this choice that a facility can't be a dual purpose facility, so to speak?
No, I don't see any reason why it couldn't be a dual facility. The capital construction costs of both are pretty significant. I think that, this is a new methodology of final disposition. It's approved in 3 other states, Colorado, Oregon, and Washington. It's going to be a philosophical choice, not an economic choice. The average cost of NOR ranges anywhere between $5,500 and $7,900. So people will certainly choose this method, not based on economics, but as a philosophical choice. But I think it's completely compatible with a crematory if they so choose.
Is the capital cost significant?
Well, I think when you talk about equipment, whether it's a crematory or a facility doing NOR, there's upfront capital costs that are fairly significant. I think that for somebody to choose to do this in Vermont, it would really be based on the demographics, and I think that the demographics of a facility right now would be pretty much anywhere in New England would come to Vermont to have the population that would desire to do this.
Question for Chris.
No, Chris, who regulates this at the moment?
Well, the House bill stipulates that OPR is going to create rules, regulations, and then oversee the running of these facilities.
Right, I understand that part, but who oversees the actual the facility itself and the emissions and stuff like that?
So
is that
I'm assuming that the EPA, if there's any emissions from this facility, which I strongly doubt there will be because it's going to be self-contained.
Yeah.
But the oversight will be through OPR and the inspection process and licensing.
Yeah. And the waste is also probably managed similarly.
Well, the whole point of this, I think, really is that there's very little waste.
There's very little, I understand that.
Right.
I think this is a terrific opportunity, and I actually think it's an economic development opportunity as well as a philosophical opportunity for Vermont and Vermont crematoriums and Vermonters. So I think that this is actually a terrific option for Vermonters to live by their mantra, which is use it up, wear it out, make it do or do without, and at the end, fully integrate back into the earth we love so much. So I think this is a terrific opportunity.
And I couldn't agree with you more. I think Vermont has been a leader on many fronts in terms of the funeral industry, and this is another opportunity for us to provide folks a really viable method of disposition.
When I was on the Development Review Board at South Burlington, we had some crematorium issues in terms of operating times and some homes being, I guess, downwind from the crematorium. Are there any kind of permitting issues you see in citing something like this at all that you might face in towns?
I really don't. I think that, what happens to the organic material beyond the actual act of reduction, will probably play a role in terms of citing a facility. I think in past testimony you've seen where facilities have areas around their facility where natural organic reduction is donated to as mulch for planting beds, reforestation and such. I think that would probably play more of a role than the actual facility itself. But at the end of the day, once the organic material is treated, it's probably as inert as the cremated remains are coming out of a crematory, and it's an opportunity to go back to a natural organic state. And I don't see any real issues in terms of permitting.
So, it doesn't have any greater impact than a crematorium. I think probably a crematorium has more impact on the environment around it.
Well, there's no doubt that, there's emissions that are regulated through the EPA from the crematory. I don't see any big hurdles in terms of environmental impact on a facility like this.
Right.
Let me ask you a question. One of the issues that's been raised is that this is a choice that may be a multi-state choice. Are there any issues regarding multi-state transportation of naturally reduced?
So there's two factors here. One is that, once the reduction has taken place, those remains, would be able to be transported anywhere beyond, because the act of natural organic reduction is considered final disposition, just as cremation is considered final disposition in Vermont and other states. What we're working with OPR on is that if another state doesn't recognize natural organic reduction as a method of final disposition, how do we work with those states to allow an individual to come to Vermont? And that's something that Director Hibbert is going to be working on. We're going to be working with her on that as well to make sure that a Vermont facility, should it develop, can serve multiple demographics beyond Vermont.
And there are other states, you mentioned Oregon, Washington, and Colorado, that have this down. Are they able to deal with remains on an interstate basis nationally, or are there restrictions that affect natural abuse remains produced by that?
My understanding from the literature of those three states, human remains are allowed to be transported from other areas to those facilities.
From those facilities back to the states from which they originated, if the for example, want to have those remains disposed of there.
Correct.
So it's a two-way street then, is that correct? Or are there
That's,
states that have restrictions right now, or the absence of laws that would prohibit that interstate transportation?
to the best of my knowledge, that is not the case, that it is permitted.
Thank you.
And Chris, just one last question. I know your initial, or somebody's initial testimony was that this was a lot less costly, it uses less energy than cremation. Can you give us a notion of what it costs in Colorado, Washington, and Oregon?
So Colorado just developed their first facility, and there was an article about 6 weeks ago talking about their first natural organic reduction case that they handled. The cost of that was around $7,900. In Washington State, I think the average cost for NOR is around $5,500. So that was misspoken by someone saying that it was less expensive than cremation, because it's not at this point.
Oh, yeah, because I think that's sort of, the Colorado cost is sort of on par with what I recall.
Right.
Vermont.
Right.
Just to follow up on some of Brock's question, so I'm clear. Presently, I mean, if this law went into effect, someone from out of state could come into Vermont, use the facility, and take the remains back out to another state without any issues, or there have to be rules developed to govern that?
In Vermont, NOR is going to be treated very similarly as cremation. So with NOR and cremation being the final disposition, there's no issue in terms of transporting cremated remains or NOR back to an original state from which they came from.
Thank you very much.
Sure, you're welcome.
Katie, can you join us, please?
Sure. Thank you.
You're welcome.
Good morning, Katie.
So we don't want to keep you very long.
It's good.
I would just say, could we walk through, it's a long bill, but could we walk through it maybe in 5 minutes, hitting the points that are,
Sure, I could sort of try to hit the high points.
The key changes maybe that have to enable this,
Okay.
that aren't,
and
that don't.
did the House change it from the way it was introduced?
Yes,
Yeah.
I did. So Katie McGlynn, Office of Legislative Counsel, for the record. I'll start by just telling you what the definition of NOR is, because it's tucked in the middle of the bill on page 17. It means the contained accelerated conversion of human remains to soil. And what this bill really does, as Chris already sort of articulated, is that it creates parity between cremation and the NOR process. So you asked, was this different from what was first introduced? Yes, the first bill that was introduced was about 20 pages longer because it was also in part a cleanup bill. There are a lot of inconsistent terms used in the Title 18 chapters on cemeteries and burials. So the original version attempted to clean some of that up. So those kind of cleanup sections were removed from the bill, and now it's pared down to more focus on that parity between cremation and NOR. So the bill amends 3 different chapters. 2 of the chapters are in Title 18 on burials, on cemeteries, and then there's a chapter in Title 26 on professions. So at the request of OPR, what is happening is there's now one term disposition facility to mean both cremation and NOR facility. So they wanted to do just one license type, and that's why they requested that. So it'd be one license for either type of facility. So a lot of the changes you'll see in this bill really bring that, we'll use that term whenever there's a more specific term like crematory, it changes it to disposition facility. Whenever there's a reference to a burial lot or burial space, or the attempt is to try to use a more generic term like a space for permanent disposition. So it's trying to not be as specific as to the type of disposition. I don't know I could start going through the sections just to maybe give you a little flavor of what's in the bill. If you, let's see, if you look on page 2, line 6, you'll see where removing crematorium, instead we have a licensed disposition facility.
Yeah.
Same change on line 10.
It's all.
Yeah, so those are the types of changes. In subsection B, it had said an operator of a crematory facility shall not cremate or, so now we're saying an operator of a disposition facility shall not cremate or process by means of natural organic reduction, or allow cremation or processing by means of natural organic reduction. So that's one type of change. You'll also see, let me see if I can find an example of it. Oh, okay, maybe page 4 will help us. So there is language in this burial transit language that talks about before such dead body shall be buried, entombed, or removed. So we're talking about sort of a specific type of disposition. So instead there's more generic language to say before permanent disposition or removal.
Right.
So it's kind of encompassing more types of disposition processes, and a similar change is on page 5, line 10. And again, page 5, line 15. There was one place where the House Committee chose not to have parity, and that was at the request of the Department of Health. So there is language about who has the right to make different disposition decisions. And at the very end of the list, there is a disposition that's happening by the chief medical examiner at the chief medical examiner's request. And the language says you have to retain the remains. I want to say it's for 3 years. Yes,
Yeah,
3
this
years.
is section 7, DCF, it says needs to hold on to the remains for 3 years.
So this all exempts, so this had a carve out for NOR because they didn't have the capacity to store those remains. Yeah.
What page is that on?
9. So there are 3 situations. Subsection D, if the disposition of the remains of a decedent is determined under the subdivision of this A10, so that.
Sorry, we don't have a D on page 9.
Oh, you don't?
No, what second? We have a 2. Oh, we have a B. We have 2 Bs.
I think I have
Passed by the House.
I have the committee report, which wasn't changed, but now
Okay, it
it's
says-
throwing the numbers off, I'm sorry.
No, it's okay.
So-
If the cremation is not arranged and paid for, the Department of Health shall pay and
What Katie tells us, the section number for the county.
I don't see a D, I see a B.
Okay. I'll have to look at your version and see how they line up.
Is it section 7 of the bill?
Yeah, that was where we heard from
Section
DCF.
7, yes. Let's see. Okay, so you're at the bottom of your page 8 and the top of your page 9. There is language. If the disposition of remains of a decedent is determined under A10, so that's this is who's making the decision of the right to disposition. The office of the chief medical examiner may contract with the funeral director or disposition facility operator to cremate the remains of the decedent. So you'll see that cremate isn't changed as permanent disposition. Same thing in 2A, if the cremation of the decedent is arranged and paid for by DCF. in subdivision 2B, if the cremation of the decedent is not arranged. Subdivision 3, the cremated remains shall be returned to the office of the chief medical examiner. The office shall retain the remains for 3 years. So that is why cremation in those instances is not changed to permanent disposition. It's not widened to include NOR
Got
because the remains, they don't have the capacity to store the size of
Those
the
are
remains.
pretty sizable.
Thank you for letting
You
me.
want to keep it for your
Well,
orienting?
I have notes on my version,
Okay,
but I will try not to use page numbers. I'll try to bring you to the sections.
Yeah.
So another change that I think is worth spending some time understanding is in the second half of the bill. We're in the OPR chapter. And let's see, it's section 25 of the bill. So you will notice there are 2 fee sections in this bill. And that's because one fee section doesn't take effect until June 30th of 2023. So we've had to amend 2 different fee sections, one that would take effect when the bill takes effect and last for the next year. And then the new fee section would be updated in 2023. So the first section is section 25, and you'll see that we're just having the sort of terms come into consistency with the rest of the bill. So in subdivision D, instead of crematory establishment, a disposition facility. Same thing in E. And then if you skip ahead to section 27, you'll see that there is a fee structure that would take effect June 1, 23. So this language was adopted but hasn't taken effect. It was adopted several years ago, as my understanding. I didn't work directly on this, but I'm updating the language here because it was enacted several years ago to reflect the new terms of disposition facility throughout anywhere that crematory establishment is used.
so this takes effect June
June.
23, and the other ones in 25 take effect
This July.
January, this July.
Yes. Oh, nope, January.
I thought
I didn't
January
read my
23.
handwriting. Yes, January. So it'll take effect when the rest of the bill takes effect January.
Right.
I guess I'm confused.
Yep, I can try again.
So we're putting in this bill, we're establishing this new process, we're putting the fees effective upon the effective date of the new structure. And then we're adjusting those fees a year out, and we
No,
decided what those fees are for a year out or 2 years out.
6 months later.
Yes, yes. And there was a comment upstairs, well, why don't we just push the whole effective date of the bill out to when the second fees take effect, and then we don't have to go through this amending it twice. And nobody ever acted on that. But basically what's happening is section 25 fees are the ones that are currently in effect. So you are amending those with the new title names.
Right.
And then section 27 has not taken effect yet. It's been enacted but not effective. And therefore, we're also updating the terms there. So when it takes effect, the terms will be correct. And it was the GovOps committee that worked on this. I have all the details of this.
So the ones in the out years, they've already been established in law by a bill passed last year. So
2018, it looks like,
Yeah.
the 2018 OPR bill, I'm reading from an email from our GovOps attorney, our former GovOps attorney. The 2018 OPR bill, which converted the funeral services profession from a board model to an advisor
Right.
model. Usually when this happens, the board model fees, which are normally higher, and codified in Title 26 get lowered and moved to where advisor model fees live in 3 VSA 125. However, in this case, the funeral profession was running at such a high deficit that OPR wanted to maintain the higher fees in Title 26 and not have the lower Title 3 fees take effect until June 1st, 23. That's why the lower funeral fees and Title 3 take effect at that date, etc. So that is sort of what happened with that piece.
Well, I don't think there's a problem, but finance will be interested in that section as well. So,
Yeah, it is a puzzlement. It does make some sense to just delay it all to June 1st, but
okay, anything else that you see, have you, in the course of this, has there been any concerns raised by anyone to the House passed bill that you're aware of?
But, you know, there were certain people who asked to testify. Since the bill is passed, I think maybe there was one email that was forwarded my way. And I don't know if any emails have been forwarded to you since that date, but the issue that was raised, I ran the question by OPR and they were not concerned with the particular issue. So I felt confident that I didn't need to be concerned about it. But that's the only thing I've heard since.
Okay, thank you very much.
thank you.
You're welcome.
We may vote this on Monday, 10 to 1. I'm not sure it's essential, but if you can be around. Okay, good, thank you.
Yeah.
Okay. Joe Dougherty or David only could stay till tomorrow.
Joe's here, David just said, let him know he was gonna holler about it.
Okay, Joe, why don't you join us? There he is. Good morning.
Morning, Mr. Chairman, members of the committee. Greetings from Salt Lake City, Utah. That's not where I'm typically based. I'm sitting in a hotel room here and happy to be chatting with you all this morning. I am the legal and legislative counsel for the National Self-Storage Association. We also manage the Vermont Self-Storage Association. I was anticipating that I would follow Mr. Hall here. I'm happy to get into the details of the bill. I know Representative Nigro testified before the committee a few weeks back. So at the moment, I will keep my comments brief and just highlight a few points here, and I'm happy to answer any questions that the committee has. So
Excuse me, Joe, I'm Allison Clarkson. Hi, I think didn't you send us a letter yesterday? Didn't we see something from you yesterday?
yes, I did, Senator, and so
that was useful prepping us for this. Thank you.
okay, great. Yes, I was just planning to briefly walk through that letter, hit a couple of the highlights of the bill.
Yeah.
So the changes that we're looking at in H74, this is a bill that started back in 2020. And as many things did, this screeched to a halt as the COVID pandemic took over. It started as H606 at that point, and the House committee took in quite a bit of testimony from the Vermont Bankers Association, Legal Aid, the Attorney General's office, and my organization, the Self-Storage Association, including some owners of self-storage facilities. And so the bill you see is a consensus bill that is based on the feedback from all of those different parties. And in broad terms, what the bill does is that it expands the disclosures that are made to consumers when they're signing a rental agreement. So they're now, I think in practice, many of these elements already exist, but there'll be a legal requirement for additional disclosures, particularly relating to fees and any limitations that are as it relates to what can be stored in the unit. There's also additional protection now for personal information that someone abandons in a storage unit, and a prohibition on selling that property. And if for some reason the property is, the storage owner is not aware that the property is in the unit and it ends up going to somebody in a sale, the owner has to advise that person before the sale is completed to return it, and then it's returned and destroyed by the storage owner. So there's that additional protection for PI.
Right.
The third item is allowing for notices to be sent really in a more effective way. So right now there's a requirement to send notices only by certified mail. And in our experience, this is something that over the last 15, 20 years, 45, 46 states have abandoned this certified mail requirement. And the reason for that is that when you send something by certified mail, if it has that green return receipt attached to it, even if the Postal Service has a new address for the person, it won't forward to that new address. And especially during the pandemic, I don't know if this is still the case now, but during the earlier days when people were concerned about maybe COVID spreads through touching items that someone else has touched,
Right.
the Postal Service wasn't even asking for signatures on these. So it really begged the question of, well, what's the purpose of this? So the bill would move either to, if there are folks who find certified mail effective, they can continue to use that. But the bill would also allow for what's called U.S. mail with certificate of mailing. This is something that it's similar to certified mail, but instead of having that return receipt attached to it, it's the Postal Service certifying at when the mail is presented at the post office that it has been put in the mail on a certain date. And if they have a forwarding address, it will go to that forwarding address. The other option that the bill introduces is email communication. And this is something, there was quite a bit of back and forth in the House about this, and the Wendy Morgan from Legal Aid also weighed in on this. And where we landed with it is to require an affirmative opt-in from the customer for any email communication. So if the customer doesn't want to communicate by email, maybe doesn't have email, whatever the case may be, they just simply don't put their email address in the rental agreement, and that's that. They haven't opted in. They can't be compelled to do that. And the other protection that the bill has is that if it is sent by email, there was concern about, well, people might not always check their email. Maybe their email address has changed. The storage owner needs to have a response, a return receipt, or a delivery confirmation. And if they don't have one of those three things, they need to send it in the regular mail, either by certified or certificate of mailing. And then the last major change that I want to highlight is permitting of online sales of the property when someone abandons. So the benefit of these online sales, especially when you get into some more rural communities, a lot of the bidders tend to be the same type of people. This isn't just like a weekend hobby that somebody kind of picks up all of a sudden. It's secondhand dealers, other people who have an interest in selling used property. So these online auctions allow them. So maybe somebody in Burlington can bid on a unit in Montpelier without having to drive all the way out there and decide, hey, do I want that? Am I the winning bidder, et cetera. So it expands the geographic reach of these auctions. And in our experience, when these occur online, you're typically talking for an in-person auction, maybe you're getting 10 or 20 cents on the dollar of the debt that's owed. When they're online, it's maybe 40 to 50% of the debt that can be recovered. And in the event that there is a recovery that's greater than the debt, that money is in all cases either returned to the tenant if you can find that person. Many times you can't because they've simply abandoned the property and don't want to be found. But in the event that you can find them, the money goes back to them. If they can't be found, it goes to the state as unclaimed property. So all of these changes that we're talking about, they've been adopted in more than 40 states over the last several years: New Hampshire, Maine, Massachusetts, just for some examples in the Northeast region. So with that, I respectfully request that the committee favorably report H74 to the Senate floor, and I'm happy to answer any questions from the committee. Thank you.
Senator Clarkson.
Yeah, thank you. So you're the storage, Joe, nice work. That's very helpful. So the storage unit owners are only able to keep what the debt that is owed to them and no more. Is that it? They can't profit from the sale of
That's correct, Senator.
yeah. So then it goes into the state's unclaimed property. Got it.
That's right.
The sale. Got it. Thanks.
I missed that last part. Where does any excess go if you can't
It goes to unclaimed property for the state.
for the state?
So the second question, I guess, is what % of storage units are abandoned like that?
So in our experience nationally, it's 1 to 2%.
Oh, so I've heard it's higher than that. Do you know what the statistics are for Vermont?
I don't. I don't know specifically for Vermont. There are about 150 to 160 facilities in the state. Most of these transactions, they go the way you'd expect them to. Somebody wants to store property for a certain amount of time. Maybe they're going through a move, or they're divorcing, or some other life event, child moving back from college, that type of thing.
I'm hip to why and how people use it. I just was curious. I had thought the abandoned rate was higher, so I'm glad to hear it's as low as 1 to 2%.
So the 150 to 160 that you mentioned, how do you know that's the number?
Facilities.
Yeah, Mr. Chair, there's a well, I'm trying to think of what I'm searching for the word here. There's a company that we use that produces something called the National Facilities Database, and they have the data on how many storage facilities are in each state, and the number they have is about 150 for Vermont.
But there's no requirement that these kinds of businesses register, or somebody actually, that company goes out and somehow combs the yellow pages or something to find these folks, or they're parts of your association. There's no formal connection between state government or local government and these facilities, correct?
No, they would register as any other business does, but there's not a storage specific licensing requirement or anything like that.
Okay. So there's nothing, there may be some other things in other states laws that you may have gotten from the industry's perspective that negotiated out or worked on a consensus basis with legal aid and the Attorney General, but you're satisfied with what has been produced from the House, correct?
Yes, we are.
Do you know, or I don't know if David Hall is there? Thank you very much. Anybody have any further questions for Joe at this point?
No.
Stay tuned. David, could you do a brief overview of the bill? I know you've done it before, so.
I have one last quick question for Joe, if I could, which is I know at one time this was a really booming, growing business. Has it sort of plateaued?
So there are a handful of markets. They're all outside of Vermont that are still booming. Dallas, Texas is an example, but generally the industry has plateaued. Some of that's the supply chain issues that we all know about. It's difficult to get the steel that is required for these facilities. So and then funding drying up during COVID. So yeah, that's a long answer to a short question, but yes, overall it has plateaued, and certainly in Vermont it has.
Thank you. Yeah, that's what I thought. Sorry.
Okay, thank you, Joe. David, welcome. How are you this morning?
Hi, good morning. I'm all right. Can I share my screen and show you the summary that I have of the House passed bill?
Perfect. And before you start, I just wanted to ask a question. Did this bill go to any other committees in the House?
I don't think so, but I haven't looked at it in a while, so I don't recall that it
Mr.
did.
Chairman, no, it did not.
Okay. Well, let me pull this up. And good morning, David Hall, Legislative Counsel. Are you seeing the section by section summary on your screen?
Yes.
Yeah,
Excuse me. So as the summary says, this is almost identical to an earlier bill passed in the House in 2020, which was H606, that governs storage units in Vermont. And, overall, we add some definitions to the chapter, specifying what we mean by owner, occupant, personal property, self-storage facility, rental agreement, just to clarify those terms. You'll see 3902 prohibits the residential use of a storage unit. 3903 specifies which disclosures an owner must make to an occupant in a rental agreement. So it's sort of modernizing that, just making sure there's full disclosure up front. 3904 creates a statutory possessory lien on personal property storage in a storage unit. So 3905 is kind of the big series here. It creates the steps in this process for enforcing the lien. If there's a default, and it specifies the rights of the parties involved. So it goes through this whole process of the timeline by which you have to send out this first notice of a default, and then a second notice of default and demand to cure, the process for advertising. And as I believe you've heard, authorizes the ability to have this advertisement and this sale happen online as long as it's in a commercially reasonable manner. So there's the process for notice to lien holders, which might include banks, and they did testify in the House on this. Then it goes to the sale of personal property, the right of redemption, what happens with the sale proceeds, how do we satisfy people who have an interest in the property, and that includes the rights of the lien holders and any rights of purchasers. There's more detail, but I'd say in a nutshell, the purpose of this bill is to, again, sort of on the front end, provide adequate notice to everybody, in the rental agreement that here's the terms, here's the fees, there's a lien created, you're in the unit until you're not. If things go south, this is how the process is going to happen. Then it specifies what the process can be, and again allows for this sort of more modernized electronic notice and sale procedure, as long as it's, again, adequately noticed and commercially reasonable. And then on the back end, how do we satisfy interests in the property in the event we do have a sale? So I don't know if you have more specific questions. I know you have a lot going on this morning, but that's sort of that's the nuts and bolts of the bill.
Now, I would like to ask Joe a question. He's still with us.
I'm sure he is.
So is there a significant majority of who rents these units in the state of Vermont? Is it a residential homeowner needing extra space, or in transition, or is it commercial people? Is there a breakdown on who's using those facilities?
Mr. Chairman, it's mostly residential users, folks who don't have space for something in their house. Maybe their house is too small, or it also does cater to folks who are in transition. Commercial, maybe depending on the facility and the location. Certainly, if you get in more rural parts of the country, it tends to be more heavily residential. If you're in more urban areas where perhaps you can't park, say, a landscaping truck on a street, or you don't have a driveway or something like that, you'll see more things like plumbers, electricians, other tradespeople, but the vast majority are residential users or people who are in transition between houses.
So thank you. One of the reasons I asked that question is I know consumers enter into contracts like this or lease agreements like this all the time. And it seems like this bill strikes a good balance of protecting their rights. But I wonder if you talk about upfront people being made aware of their rights. I'm wondering if you see different form contracts that sort of make things bold or make people initial certain sections that the message is getting across to them that they have some rights. And if you've seen any variation in the model contracts or laws around the country in that respect.
Mr. Chairman, the answer to that is yes, and that is incorporated into this bill. There are requirements for certain font sizes or bold type for certain of the key provisions that Mr. Hall was talking about.
And what would be one or two of the most important consumer protections that the consumer, I mean, I know you represent the industry, but you also seem to be very straightforward about it. And so what would be one or two examples of the rights that consumers might not know about, or, you know, be helpful for them to understand upfront?
Mr. Chairman, the most important is that there is a lien created on the property when it's stored in the storage unit, and if they fail to pay or abandon the property, it can be sold. So that's probably the key item that folks need to know about, and that would be required to be in bold type according to this bill, with a font size either equal to or greater than the general text of the bill. The other probably most important element is just relating to expenses and fees for rental of the unit, so that everybody knows here's the cost going in, and if you are late in making a payment, here is the late payment fee for that. Another item that we negotiated in the House relates to disclosure of any requirements for security deposits. That's something that is perhaps a little peculiar to Vermont. We don't typically see security deposits for these agreements, but there were a few owners who testified that they do take small security deposits. So the bill now requires that be set out in the rental agreement, advising, okay, here's a security deposit, and here are the steps that need to be taken, or you know, when we can withhold it and when we return it to you. Those are the highlights in terms of what is disclosed to the tenant in the rental agreement in bold type and larger font.
Okay. Appreciate you both being here. That was very helpful. Good summary. Any questions for David?
No, I think we're a little behind the 8 ball on this, if 40 other states have done it. It sounds like we've yet again added some additional protections, but I think it's time for us to do this.
Okay, thank you much. We're going to move on to H320. And David,
I live and breathe.
why am I not so around?
Did I time this perfectly?
Thank you, Joe and David.
You guys, Joe, very helpful.
This is the Do Not Darken My Door bill, H320. We got testimony on it, and David has walked us through. It's a short bill, I think. I'm going to ask David to give us an overview, not necessarily what it does, because we want to hear from, we have a witness that I think has some concerns with the bill that we want to make sure we have time to hear from.
Yeah.
So yes,
And we also have a request to consider adding sections 1 and 2, I believe, from 329. So,
Danny may have some information on that for us. So I think there may be some of this stuff may have already been incorporated. I may be wrong. But, well, Davey, welcome.
Hi, good morning. For the record, Damian Leonard, Office of Legislative Counsel. So H320, if you'll remember back to 2017, 2018, when we passed the
right.
sexual harassment bill, at that point, we prohibited what are commonly called "do not darken my door" provisions. It's essentially a provision in a settlement agreement that says we're agreeing that you will not either work for or apply for a job with this company or this employer and any subsidiary or parent company, et cetera, of that employer, division, affiliate. So, and what this would do is we prohibited those with respect to sexual harassment settlements. We did not prohibit them with respect to other employment discrimination settlements. So what H320 would do is it would prohibit them with respect to other employment discrimination settlements. The arguments very briefly for and against. On one side, the argument is that these provisions are retaliatory. On the other side, the argument is that these provisions provide a tool in the toolbox when you're settling one of these cases, and it's something that you can negotiate, and very often the employment relationship is already fractured. So, and that is the very, very high level view, and I'm sure the witness you're going to hear from can provide you with more depth on that. But this would apply to any settlement agreement that's entered into on or after July 1 of this year. So there is language in here saying that it doesn't apply to settlement agreements that are already out there. That language is not entirely necessary, but it's in there for clarity, because a lot of people don't realize that 1 VSA 214 exists, which prohibits retroactive effect. So
Also, there'll be a contract clause issue potentially, right?
yes, if we were trying to apply this retroactively, if we not withstood 1 VSA 214, we'd be getting into contracts clause issues where we're depriving people of economic benefits that they negotiated.
So just by way of background, I think we were probably one of the first states in the country to do this back in 2018. But then several members of this committee sponsored a bill similar to this, if not identical, that passed the full Senate and died in the House. And now they're sending us essentially the same version back in H320. So we have had testimony on this. And we did. I don't know. I can't remember what the committee was. But it passed before it went to the Senate. House. Correct to that?
So it passed the Senate, I believe, and didn't go anywhere in the House.
Right.
I think
Was that just timing?
I think it was a timing issue.
Yeah, I do too. I don't think it was, because they've said basically some more thing back.
Yeah, I remember that they started taking testimony on it, and I can't remember if it was that the pandemic occurred and they just didn't take it up again, or if they just had too much on their plate and decided that they couldn't take on an additional issue. I remember the testimony, but I can't remember the reason why they didn't continue working on it. So.
trying to think if we need any further testimony from like AG or Julio. So Julio from the AG's office is the person who's most interested in this.
Yeah.
So the committee upstairs heard from Julio and Yang, and then, you know, a variety of different interest groups. And then from employer groups as well as attorneys who represent employers and plaintiffs in these cases. So
Would you say that Orr and the Attorney General were supportive of what the House did?
my recollection is that their testimony was generally supportive.
So I would suggest, Mr. Chair, that in lieu of our taking additional testimony, although, because if they were supportive, I believe they're probably supportive of this, is that we take the time to look at their testimony in the other committees, you know, not in committee time, so we could do that, so that we don't take up, I mean, our time is so short that it would be great. I think I'd love to get this passed and have us take the time to look at those
Well, we have, I know, we
testimonies.
do have, I did look at some testimony from the House, from another attorney, from here from Richard Cassidy, but
Oh, right.
another attorney who did produce written testimony, so you can take a look at that. And that's the opposing point of view over here from Richard. So thank you for sticking around, David, if you can.
I'll
And
just be right here.
thank you, Richard, for being with us on such short notice. I know you did testify on, at least as this bill applies to harassment claims. I don't know if we had you in again on the broader bill, but welcome and explain to us your position on H320 at this point.
Well, thank you, Senator Trott and members of the committee. As the Senator said, my name is Richard Cassidy. I practiced law here in Burlington for 40 years. And before that, I was a law clerk for 2 years at the Vermont Supreme Court. And I've been a student of our Fair Employment Practices Act throughout that time period. When I was a law clerk, my justice, Chief Justice Barney, wrote the very first employment discrimination case ever interpreting the Fair Employment Practices Act. So I've watched it develop all these years. I'm very sympathetic with the goals of H320 to protect victims of discrimination from further victimization by being prevented from seeking future employment with the employer who originally discriminated against or retaliated against them. It seems like a good idea, but I'm very much afraid that this is a situation in which the unintended consequences of the legislation far outweigh its benefits. Most claimants in discrimination cases have been fired already or have left their employment already. Adverse job action of some sort is an essential element of an employment discrimination case. There are other things that could amount to adverse job action, but in most cases, the employee has left. So you're talking about a situation in which there's already been a real breach in the employment relationship. Most of these cases will be settled in the end. And when I say most, I mean the overwhelming majority of them will be settled. The judicial process is fundamentally a dispute resolution process. It looks to resolve cases. And discrimination cases are very hard for plaintiffs to prove. They rest, most of the cases that would be relevant to your considerations are intentional discrimination cases. They rest on proving what electrical impulse passed through the brain of the alleged discriminator at the time the decision was made. That's a really tough thing to show. Unless the decision maker has admitted discrimination, and we don't see very many of those cases anymore, winning these cases is a tall order. The public has an impression about these cases based upon a very few cases that result in high verdicts or high settlement numbers. Most cases don't. I know this based on my own personal experience representing almost exclusively employees, and I know it based upon the only really good study of these cases I've ever seen, a study that was done by the American Bar Foundation, which is somewhat dated now, which suggests that almost 20% of the cases are dismissed outright. 49% of the cases are settled early, usually for very small payments. That's usually a signal that it's a small settlement. Almost 20% of the cases are lost on summary judgment. 8% of the cases are settled after summary judgment is denied. And those are the cases which are settled for significant payments. 6% of the cases get tried, and employers win 2/3 of the time when cases get tried. Employers. So just because you're the victim of discrimination doesn't mean you have a good case you can prove. And just because you think you've been discriminated against doesn't mean you have. Ignorance of the law in this area is broad, and lots of people think they've been discriminated against when nothing of the sort has happened. So the cases are mostly going to settle. And one of the most important trading cards in settlement is promising to give the employer closure in what has been a bad situation for the employer. They want to bring the case to an end. If the employee can turn around and apply for a job tomorrow, the case is not at an end because the case can be revived in a moment. So this trading card, the right to agree not to seek reemployment, not to accept reemployment with the employer, is a very important card at the bargaining table. If employees don't have it, they will have a very hard time settling cases. Employers have huge resources with which to defend themselves. They're not afraid to use them. And the effect of this legislation, if it's adopted, will be to make it harder for people who need some legal protection to get any help at all. So for all those reasons, I just urge you to reject this legislation. Thank you.
Thank you, Richard. So you kept using the word discrimination. Is the law that's on the books of harassment, is that considered, is that in the group of discrimination you're talking
I
about?
can't quite hear your question, Senator Sorokin.
I'm saying is when you keep talking about discrimination and the study
Yes.
cases, you kept using the word discrimination. Do you consider what we passed already on harassment as being in the group of discrimination?
Yes, it is a subvariant, I would call it, of discrimination law. It really the laws against harassment came to be illegal because some very creative, bright women lawyers in New York managed to take the frame of the discrimination statutes and say, what is happening when women are being sexually harassed at work is a kind of discrimination. And they managed to persuade the courts that that was theoretically correct. So yes, those are a kind of discrimination cases in my mind.
Do you see any distinction between sexual harassment and all the other forms of discrimination that we swept in by this bill? Is the problems you've identified articulately, are they there equally for all the other forms of harassment? I mean, all the other forms of discrimination as they were in our discussion of sexual harassment a few years ago?
I think, frankly, that they are. I think if anything, harassment cases are more difficult to settle than other forms of discrimination cases because the charge is so offensive to the persons who are defendants, and overcoming that personal upset and anger is a real hurdle to settlement. So you need all the cards you can have to bring those cases to resolution as well.
The reason I ask, and we could send you a copy of Stephen Ellis's testimony, it seemed like he distinguished between harassment and discrimination, almost saying that while it may have been, the do not darken my door may have made more sense in the harassment context than it does in the discrimination or these other classifications. So we'll send you that. And
Well, let me say this, Senator, by way of sort of anecdotal experience. A long time ago, I represented a very bright young woman who was sexually harassed in a corporate hierarchical setting. And we mediated the case. It was way before mediation was common. One of the first mediations done in an employment case in Vermont. And the case settled. The mediator came into the room we were in, and he pointed to the window and he said, I want you to look out there. Her boss, who had been harassing her, was taking his plaques to the car. He'd been fired. Now, she was able to go back to work because the CEO of the company got it, understood that she'd been harassed by the person who sat between them, and was prepared to make the hard decision, let the higher status person go and keep my client. She stayed in her job. She got 2 promotions. That's a great result when that happens. It's not usually what happens.
Right.
Usually when one of these claims is made, the employment relationship is irrevocably destroyed. And it's regrettable, but it's true.
so what happens if in the bill we passed that outlawed these clauses in sexual harassment cases, if someone went back, let's say, to the state of Vermont and said, you have a similar job down in Bennington County and have one in Burlington, I want to apply for that job. If under existing, the new law, if the state said no, one assumes that there would be another sexual discrimination claim filed for not getting an interview or the job?
I didn't really understand the question, Senator.
Quiet, you can't hear you.
I'm sorry. I'm trying to understand the downside of what, from an employer's perspective, of what we did with our do not darken our door law. So if that claimant went ahead and reapplied for a job and was told no, would you expect that that claimant would say, well, you're discriminating against me again by not giving me the job?
I would think that that's a possible result. When I think about these cases and about which cases are economically viable, because they're complex and difficult, it's expensive to pursue them. No hire cases are less attractive cases than termination cases. And it's just, juries just don't have that much interest in a situation in which somebody just doesn't get hired for a job. The situations in which people get fired from jobs are much more sympathetic because the person built their life typically on the job, their mortgage rests on the job, their ability to feed their kids rests upon the job. When you're talking about a no hire situation, it's usually not the same connection. But technically speaking, yes, a no hire case is a valid discrimination or harassment case, or can be.
So doesn't that sort of undermine the argument that employers insist upon you not reapplying for a job in terms of their settlements if there's really no risk or little risk to the employer for saying no to a subsequent employment request?
Well, I think plaintiffs' lawyers evaluate cases in a far different way than defense lawyers do. Defendants just don't want to have claims and lawsuits to defend. I don't want to have cases I can't win.
Right.
So I'm a very tough critic of the cases I'm willing to take because I can't spend $150,000 on a loser. And I may have to do that in order to pursue one of these cases. the defense lawyer doesn't want his client to get a claim presented against him. And it's easy for anybody to file a claim with the Attorney General's office. And anybody can do it without even a lawyer, almost anybody. And now there is a claim to defend and legal fees to pay and business trouble to face. So employers are very claim averse, even about claims that are not well-founded.
Senator Fox, your question?
Thank you, Richard. I believe you testified with us in 2018.
I did.
I know, I remember you from that moment. So many of these cases are with individuals. So I guess I'm struggling with the an individual manager or employer who's making choices that put the employee into either being harassed or a discrimination case. But it's with individuals. And I think the challenge I'm facing is looking at businesses that are regionally or nationally owned, and to have this tool to cut people off from employment, either regionally with a business that's regional or national, it's fairly, I think that's tough when the problem may just be with a lousy manager or a lousy boss who is, do you see my question? So I mean, I think it's a big, to keep it as a tool is great. I absolutely understand that piece, but I also think, wow, that's a tool that has big impact in terms of companies that may be large, and it may have just been a problem with an individual at that larger company.
Let me say that
I don't know how to ask that question in a clearer way.
I think I can help you with it. I do a lot of work. I do an increasing amount of work as a mediator, which is a wonderful vantage point to see both sides of these cases. And one thing that I see, which is quite surprising, really, is how differently the cases are, the same facts are seen by the parties. And I attribute that to a feature of human nature that the psychologist will call confirmation bias. So it's human nature to accredit the information that's consistent with what we believe and discredit the information that is inconsistent with it. The effect of bringing an employment discrimination claim on a corporate employer is to line up every employee of the corporation who knows about the claim and is in management against you, because they're going to believe that the case is they're going to believe in their heart of hearts most of the time, not always, but most of the time, that you're wrong and they're right. So it just isn't personal between the decision maker and the employee. The view that is taken in most of these cases by the employer is that employee's a bad apple. And that's why they're doing this, and they're playing a game. And I tell you, even when that's not correct, that's what they mostly believe. We all have the ability to justify our own behavior, and we sure use it. So I don't think that just the fact that this is a large entity means that it's not a problem. Certainly large entities that want to try and be more thoughtful about it have a greater opportunity to do that, because they can place somebody in an office that's 100 miles away, but the rumor mill is about, and it's always going to be tough.
Have you seen, is Vermont unique for in the minority of states that have passed do not knock on my door legislation?
I don't I don't know the answer to that question, Senator. I am a member of the National Employment Lawyers Association. And, that's the association of individual attorneys who represent individual employees. I could probably get a pretty good survey by querying the membership on our listserv. Pretty fast.
Yeah.
I'll
Okay.
try if you like.
Okay, thank you. Also, have you seen any variations on this law that limit modifications on the do not knock at my door, like saying you can't do it for out-of-state franchises or
Yeah.
locations that are 100 miles away or something like that?
What I have seen is not in the law, but in settlements that I've negotiated or helped to facilitate the negotiation of. And the variation that I see are term limits in effect. So, in 3 years or 5 years, the people that run the business are going to mostly turn over. And oftentimes, I won't say oftentimes, but you can sometimes negotiate a deal where the employee agrees not to reapply for 3 years, 4 years, or 5 years. And the employer may go along with that.
So is that something you'd recommend as a keeping some piece of this tool in the toolbox? Is that something because my next question was going to be what would you recommend so that we could maybe keep pieces of that tool? Because you make, obviously you make a good argument, but without compromising the rest of this.
I cannot persuade myself that this is a good idea. And I
Well,
cannot persuade myself that a variation of it is a good idea.
Okay.
I'd like to, because I'm very sympathetic with the intent. It just doesn't feel right to say that the employee's been discriminated against and now they can't go back to work at that company. I get that.
I was going to ask you, in the real world of your practice, how many employment discrimination cases would you say you've had over the years or inquiries?
Hundreds and hundreds. I'm not taking new cases right now for, I'm like 3 months out because I get so many calls that I can't manage them.
And of those individual employments, how many have you seen, or percentage or number would you say, that have had this as a concern, that they might have to sign something that sort of is punitive against them after being discriminated against?
Well, it's a standard piece of boilerplate in the employer settlement agreements. If one of the usual players in the game represents the employer, any one of the big law firms is going to come forward with no reemployment legislation language in their agreement.
Hopefully not anymore.
Well,
Correct.
not if you make it illegal, but
Sexual harassment, anyhow.
right. But in the generic discrimination setting, you're going to see that language.
No, I guess what I'm asking is, you started out by saying this is a very valuable tool to the individual. And I'm trying to determine, have you seen cases where the injured party, the claimant, has wanted to say, I may want to go back to that job. So this is important that this clause not be in here. Or, do they, most of them just said, I don't care, that's meaningless to me.
Yeah. Yeah, no, I certainly have seen that. I can't give you a percentage, a number of cases. But, there are certainly situations in which the employee wants to go back. And in the present situation, that's a subject of negotiation. It's usually not a successful negotiation for the employee because the employer doesn't want them back. But sometimes it is, but I would say, I could start thinking through the hundreds and hundreds of cases I've handled that involve discrimination cases. And I could start picking out the cases where the employee actually went back. And we're talking 5 or 10 or something, not many.
Surplus.
Richard, what percent of your cases are sexual harassment discrimination cases versus other types of, other types of discrimination?
Sexual harassment cases are more rare than garden variety discrimination cases.
That's interesting.
In my experience, I have frankly become more leery of handling harassment cases of all kinds because of the legislation that's been adopted and the greater public scrutiny and the hoops that I'm going to have to go through to handle those cases. A really strong case, you're going to take anyway, but you don't see that many, they tend to be what I would call minor league harassment cases. And I know there was talk about in the Senate Judiciary about rewriting the entire Fair Employment Practices Act, which I think is an idea that has some potential. And I said, I believe when I was testified before this committee back in 2018, that I thought one thing that could be done that would really be a service, particularly to women who are victims of harassment, is to loosen the requirement around what you have to show in terms of how bad the harassment has to be. So in order to be harassment that's can be addressed by the law, it must affect the terms and conditions of employment. It must be so severe and pervasive that it affects the terms and conditions of employment. That makes cases of low-level, ugly conduct beyond the reach of the law. And I have to say, women shouldn't have to put up with that stuff. They really shouldn't.
We're going to have to go to the floor.
Okay, if I could change one thing, I'd change that.
Okay, and we're going to send you Stephen Ellis's testimony.
All right. And I'll make a posting on the website to see what I can find out about other states.
So that would be great.
Great. Thank you.
Thank
very
you.
much.
And
Thank you, David.